Let's go on to part 3. Ms. Heard is not entitled to rely on Virginia's anti-SLAPP statute. All right, so here's where they get into a little bit more meat on with the argument here. Okay. Here, the court need not reach the factual question of whether Ms. Heard acted with malice in falsely accusing Mr. Depp of abusing her, which she necessarily did because the statute is inapplicable to Mr. Depp's claims against Ms. Heard as a matter of law for the reasons set forth below. So, I mean, they do kind of address the actual malice issue, but I still think that they could have and probably maybe should have made the argument that even if she, somehow was making the statement for, the statement was solely under matters or solely regarding matters of public concern, that she still was acting with actual malice. Anyhow, okay. First, Mr. Depp is not seeking to hold Miss Heard liable. Did I say Mr. Heard? Let me restart that sentence. First, Mr. Depp is not seeking to hold Mr. Heard liable for any assertion that could be construed as a statement of public concern, but rather for a defamatory implication about the private events or non-events of her relationship with Mr. Depp. That is Mr. Heard's God, why do I keep doing that? That is Miss Heard's potential liability for defamation arises solely out of the defamatory implication of her words that Mr. Depp abused her. Courts have recognized repeatedly that liability for defamation may rest on defamatory innuendo, which is no more protected by the First Amendment than is defamatory speech expressed by any other means. And then it cites to a Virginia Supreme Court case, Pendleton versus Newsom. In such a case, defamation by implication in such a case of defamation by implication, liability is obviously and necessarily based on the defamatory innuendo and not on any other meaning that could be derived from the words at issue. Thus, for instance, in Pendleton, the Virginia Supreme Court explained that even a literally true statement that might otherwise be protected by the First Amendment is actionable where it contains a defamatory innuendo and allowed a case to proceed based on the defamatory meaning of the words when read in context. The court noted that because defamatory speech falls outside the protection of the First Amendment, a First Amendment analysis is inapposite in a case in which a plaintiff must allege and ultimately prove that the defendant intended his words to express a defamatory innuendo, that the words actually did so, and that the plaintiff was actually defamed thereby. In other words, the proper focus of the court's inquiry is the defamatory innuendo about the plaintiff, not on on any other meaning that might be ascribed to the words at issue. Here, as in Pendleton, Ms. Heard has been sued for the defamatory innuendo of her words. And then it cites to Pendleton with quotations. In this context, it is clear that any defamatory implication was aimed directly at the plaintiff. And here, as in Pendleton, that defamatory implication is not entitled to protection under the First Amendment. And then it cites again with another citation or another quotation from Pendleton. Defendants also argue that their statements were protected by the First Amendment. Again, that position may be sound if the statements were read out of context, but a defamatory innuendo is no more protected by the First Amendment than is defamatory speech expressed by any other means. So basically, this is talking about Pendleton. Now, that case was about a really sad situation. I looked this up earlier. So there was a 7-year-old student who was allergic to peanuts, and at the school, she came in contact with one. And before this point, the mother had previously provided all kinds of information about it. She had a whole medical plan and everything. She had provided like a junior EpiPen, and the school ended up being like, no, actually keep this for yourself. We have stuff, here in case anything happens. So but the mom had done a series of steps to make sure that her daughter was safe at school in case she ever came in contact with one of the things that she was allergic to, that she was deathly allergic to. And unfortunately, she came in contact, she had ingested a peanut or something and then died. And then I believe she sued the school. And then in the process of responding to media requests and also concerned parents that wanted to make sure that their kids were safe. The various defendants that were different school administrators and I think the principal and other people, um, there were a number of responses where they basically said yes, this is tragic, and these things can be prevented if the parent actually communicates with us and gives us all of the important information for their child to be safe and provides us with XYZ. Like, these are all things that the mother actually did. But the way that they said their policy in response to questions of concern, in response to, media requests about the case, made it sound like they were saying, yeah, the mom didn't do what she was supposed to do here. She's kind of actually to blame. She's responsible for her child to some extent that we are not fully responsible for. And that's not true. So technically what they were saying was true. That was a policy that they had, and that was something that is beneficial and is preventative for any kid in that kind of a situation. But in that situation, because of the way that they put it, it implied that the mother was somehow to blame, and that is factually incorrect in context and by innuendo. And so basically that does apply very closely to this case, where Amber Heard in her Washington Post op-ed said, "I received all of this hate after everything and society, blah blah blah, this stuff." Like, she probably did endure a lot afterwards. That isn't necessarily because the allegations that she made were true, right? Because there are a lot of people that have believed for a long time that those allegations are not true. So, okay, coming back to the MSJ, after kind of giving a little bit of background on that case, the defamatory implication Ms. Heard made about Mr. Depp in the op-ed is not regarding matters of public concern because it pertains only to what allegedly occurred in her private domestic relationship with Mr. Depp. As generally analyzed by courts, a matter of public concern is one which relates to a matter of political, social, or other concern in the community, as opposed to a matter of only personal interest. And then it cites DeConnick v. Myers, which is a United States Supreme Court case. And that one is let me see here. Hang on a second. That one is interesting too, because that one, it was more about an employment situation, but the definition is still basically the same. Um it's a matter of political, social, or other concern to the community. And not technically. Typically, when these sorry, I am looking for something specific here. I have some case law that I pulled up elsewhere. Okay. So I'm going to pull up some. Oh, I didn't realize that I was still showing all of that. Not I pulled all of that up anyway for this anyhow. Okay. So when we're talking about matters of public concern, courts typically are going to look at something like elections. Talking about elections, that's going to be a matter of public concern. Talking about any kind of government proceedings, that's generally going to be pretty solidly matters of public concern. Here, a lot of these cases have been talking about situations of employment for the government, so there can be some kind of a blend between the two. But courts are pretty particular. They say that, when you have a situation where there are public proceedings involved in, let's say, letting an employee go from a government job, there are certain due process things that have to happen. So, statements can be made about that which are of public concern, but sometimes the speech is simply a grievance of a purely personal nature, which is not a matter of public concern. This is something that is a personal thing, and so therefore it wouldn't fall under It wouldn't fall under the statute here um, in Virginia. And so here, the motion for summary judgment also goes on. It says newsworthiness alone is not enough, and references to particular private grievances generally do not rise to the level of matters of public concern. And then it cites to the 10th Circuit, which says, noting the lack of public concern with respect to a statement that merely deals with personal disputes and grievances unrelated to the public's interest, and explaining that speech that airs grievances of a purely personal nature typically does not involve matters of public concern. So this now, when we're talking about using case law, so Connick v. Myers is the United States Supreme Court, which is going to be binding on every single court, right? It is the highest court in the United States. Here, 10th Circuit is not 10th Circuit is not where Virginia is. It doesn't cover Virginia, so it's not binding, but it is persuasive. So either party can use case law from other jurisdictions, but if there is something that comes from either Virginia state courts or from the 4th Circuit, because that is federal, but it covers Virginia, then that would be stronger. But personally, I couldn't find anything. I researched a little bit. I couldn't find anything in the 4th Circuit or in Virginia that covers this specific issue, which is kind of interesting because it is a Virginia statute that we're talking about. And I would think that there would be some litigation on this issue. Anyhow, going back to this. Simply stated, Mr. Depp is not suing Ms. Heard for making statements about society in general. Rather, he was suing her for publicly naming him as an abuser and forever tarnishing his good name, an act that, coming from an ex-spouse, is fundamentally personal in nature. Only if the defamatory innuendo at issue were regarding a matter of public concern could Ms. Heard credibly seek to rely on the anti-SLAPP statute. Regardless of its ultimate outcome, the nature and basis of Mr. Depp's allegations preclude application of the anti-SLAPP statute, since a claim that a particular individual was abusive in a domestic relationship is simply not a matter of public concern. As in Pendleton, this is a case about defamatory innuendo targeting a single person. So one thing that I think actually would have made this a little bit stronger, if I had my druthers, and this might be just a little bit nitpicky, but I would, looking through the docket, I saw that there was one of the court's orders in this case, was it talked a lot about this Pendleton case. And it talked about, it was actually one of the first motions to dismiss, I think the first one actually, where Amber Heard tried to get the complaint dismissed because of the fact that it doesn't specifically name him. But yeah, the court totally looked at it a bunch and determined that yes, this is fine. This case is fine. You can have a statement that is defamatory by innuendo. So in this motion for summary judgment, I would actually say not only have courts determined this, but this particular court has determined that in this particular situation, this falls under a situation just like Pendleton. So the second reason why Johnny Depp says that Ms. Heard needs to be taken down from the anti-SLAPP litigation is, second, Ms. Heard's attempt to take advantage of the anti-SLAPP statute also fails because her liability arises out of a course of conduct that is broader and older than the op-ed, much of which manifestly did not consist of statements of public concern. The anti-SLAPP statute only applies when a claim for defamation is brought solely based on a statement regarding matters of public concern. But here, Ms. Heard's liability arises out of a course of conduct that culminated in her revival of her abuse allegations in the op-ed. Mr. Depp's claim for defamation is not solely based on the contents of the op-ed. It is also based on other conduct of Ms. Heard, such as her actions when on May 27, 2016, Ms. Heard walked into California State Court with bruises on her face in full view of the press to obtain a domestic violence restraining order, a fact that she specifically alleged in her own counterclaim. Okay. Ms. Heard's prior conduct in seeking a domestic violence restraining order and parading in front of cameras with supposed bruises on her face, marks which two sets of police officers testified did not exist, cannot be construed as anything other than acts that are fundamentally personal in nature, focused on a personal dispute between Mr. Depp and Ms. Heard at the bitter end of their marriage. Now, this part right here, I'm not so sure that I like it in terms of a strong argument. In other words, to be more clear, I don't think that is the strongest argument. At least I don't know that I would have gone with that, because so courts have long held that conduct can be considered speech. Some types of conduct can be considered speech, but I think that walking around with bruises on your face are not necessarily uh, those on their own are not acts that could be statements. I understand that, taken in the context, maybe you could look at it a little bit differently because of the fact that she's going into the courthouse. She's got cameras that she knows are going to be there. She's doing it specifically. Or at least, the allegation anyhow is that she had specifically had these dressed up bruises on her face for the purposes of trying to convince the court that she, needed a restraining order against him for domestic violence. Um, but it's strange that this is something that is being characterized as a statement. To me, I don't necessarily like that argument, but I understand that basically what they're getting at is their overall argument has been, and the court has agreed with them in the past, that the Washington Post article was basically a in a sense a republishing of her previous statements about, alleging domestic abuse, which restarts the statute of limitations. So, he's able to kind of reach back to these other statements that she's made about these other incidents, about, the throwing the phone at her face supposedly, and the Australia incident, and all kinds of different things that she's alleged in the past. So he's able to kind of reach back further because of the fact that the Washington Post article, by implication, by innuendo, also reaches back to those various incidents. So, I understand that that's basically what they're getting at here, but I think that the way that they go about it is maybe not the best. Okay. Not to say that this is going to be a failing argument because of that, but it's just me stating my opinion as we go through. And yeah, don't forget to use your gavel on the like button and ring that bell. Thanks, Secret Squirrel. um, and then they cite to Jones versus Union County of the Sixth Circuit, commenting that while combating domestic violence might generally be a matter of public concern, a particular instance of seeking protection from an abusive spouse was far more a matter of private interest than public concern. Now, again, this is not binding authority. This is persuasive authority, so the court can choose to ignore it. But the court might be very well interested in going in and reading this court opinion's reasoning to see if it's something that is relatively parallel to what a Virginia court would say. But it's an important thing to note that some courts, somewhere have made that distinction. Thus, Ms. Heard's op-ed did not occur as an isolated event, but occurred in the context of that prior conduct and Ms. Heard's prior allegations. As such, Ms. Heard may not simply rely on a mechanical argument that if the op-ed touches on matters of public concern, she is automatically entitled to employ the anti-SLAPP statute. And that is true. That is true. You can't just couch a private concern. You can't just couch a private concern with a public matter and say I'm not really talking about this private thing where I may or may not have been lying about this other person that they did something terrible, but they, just because you are also talking about a matter of public concern doesn't mean that you automatically can say whatever you want about a private matter. Okay. Um, Mr. Depp's claim for defamation is not based solely on the op-ed read in isolation, but rather the op-ed in its full context. And then it cites to Smithfield Foods, the United Food and Commercial Workers International, noting that the omitted section of the above statute, which protects from liability based solely on statements made at a public hearing, was not applicable when the conduct at issue involves far more than statements made solely at public hearings. And this is another situation where I would have, just to kind of hammer the point even further, I would have wanted this to say, if I were writing it, I would have wanted this to say, uh, and in so many words, that the court has concluded, the court has agreed so far in this case that Mr. Depp's claim for defamation is not based solely on the op-ed read in isolation, but rather the op-ed in its full context. Like maybe say that and then say, oh yeah, and the court has agreed, because this is just kind of like saying, hey, like, we're not trying to convince you of anything that you haven't said otherwise. Like you've already basically agreed with almost our entire argument. So let us help you along the way to so that you can fully agree with us on these other things that you may or may not have made a decision on yet. Part 5, conclusion. For the foregoing reasons, the court should grant Mr. Depp's motion and find that Ms. Heard is not entitled to anti-SLAPP immunity. Okay. So, and then that's basically the end of it. It was filed on March 22nd.